A bench of 5 judges of the Court of Appeal were on Friday morning treated to the shock of their lives when they were told that they are irresponsible and have already resolved a matter that was yet to be debated before them. As if that was not enough, they were told that they have produced a judgment and therefore the proceedings were a mere formality. Lawyers representing former President Khama also walked out of the proceedings, saying they have been instructed not to take part in the appeal by the Directorate of Intelligence and Security Services. The senior judges fired a barrage of questions, trying to understand, among others, whether the former president had a copy of the said judgment and what should happen to the papers and all processes the lawyers followed in response to the appeal. This is what the lawyers had to say outside court.
We have appeared before the Court of Appeal only to make it known to them that our client will not be participating further in these 2 consolidated appeals. And his concerns are with regards to the lack of impartiality of the panel of judges. We did write a letter to the Judge President on the 10th of October this year to say that client has it on good authority that decisions in the 2 appeals have already been made, and therefore he will not get any fair hearing or any justice out of further participation in these appeals. He did request that the Judge President should consider impaneling a different panel of judges who are independent. And we believe it was easy to do so because there are members of this court who are not affected by the politics of this country, who will not be so invested into the outcome of these appeals, who may render justice.
When you say independent, what exactly do you mean?
Those who have not participated in a predetermination of the outcome of the appeals. Yes, that is what we mean.
Okay.
Yes.
So, you mean that the Court of Appeal has already made a decision? How do you know that? How does your client know that?
Well, effectively, client says he has been reliably informed, and if that is the case, obviously it will be an illegal thing to do. So it might be dangerous to disclose the source because we have seen how government victimizes anybody who stands for the right thing. So he is reliably informed that judgments have already been prepared in the 2 appeals, and therefore this is just a sham, a facade, a formality that will mean absolutely nothing but to formalize or to legalize what is already happened, which is illegal.
Okay. The judges asked you already, does your client have the copies of the judgment?
Well, I don't think if they had done such an egregious thing, they would make copies available, because it will be an indictment on themselves. Each one of them will have to resign. So if it is true that those judgments have been prepared, I don't think anybody will be imprudent enough, for lack of a better word, to make those judgments available and still call us to court to appear when judgments have already been made, because it will be proof that an illegality has happened.
So are you going to accept the ruling at this court?
Well, if
the decision?
We already know what the decision is. The court may vindicate itself and come to a different decision. So we will look at the decision when it comes out. It's difficult to say what it will be. If it is what we have been told it is, obviously it is illegal because it was taken before a process which usually happens to hear the party who is appealing and to hear the one who is defending the judgments of the High Court and make a decision. So if it's predetermined, really it is illegal, it's illegitimate, it cannot be acceptable in a democratic society.
Are we going to see more of these in future where the former president is involved?
It will depend on whether the judiciary will redeem itself, whether the leadership of this country will see to it that the institutions of this country, who are losing credibility day and night, recover their integrity.
Nonetheless, the matter proceeded without the respondents, and the DIS argued that they have to be allowed to search State House 4, where they believe multiple guns and ammunition are illegally kept by the former president, who now resides in South Africa. They argued that the lower court was wrong to disallow them to search State House 4, stating that the DIS Act gives them power to search anybody or property they believe poses a threat to national security. This is what Sifelani Thapelo had to say about his colleagues' walkout.
As far as we are concerned, their walking out is inconsequential. They are at liberty not to participate in the appeal, and the walking out would have no impact on the outcome of the appeal.
They raised a number of issues about judgment. What is your comment on that?
Like we pointed out in open court, we were not copied in those correspondence. We haven't seen the letters in question. We have no knowledge of the allegations contained in those letters, and we can't really comment.
So how are you going to handle this incident in future? In the event of a walkout in whichever case?
Well, that's not for us, it's for the court. They were not walking away from us, they were walking away from the court.